Hello, I am Gustavo Balmaceda, Academic Director of Tutors, Law Training, and I warmly welcome you to our criminal law classes. We are going to begin now with the study of the fundamentals of criminal law. When? We naturally start from the general to the particular, and when we want to talk about the foundations of criminal law, in principle we have to say that they are sufficient to be able to regulate peaceful human coexistence. Sorry, the means of informal social control are sufficient. Who are those who are rooted in the community? Faced with undesirable behaviors, here we are referring to means of social control, means to ensure peaceful human coexistence, and that are spontaneous, which although they could have legal regulation, it is not necessary for them to have it. I'm talking about family, religion, neighborhood council, sports clubs, rock band fans, etc. Criminal law. The last radio must be the last remedy available to the state to resolve conflicts to ensure peaceful human coexistence. In this sense, the function of criminal law is to protect legal assets through the motivation of citizens. In that sense, we have to say that within the means of formalized social control, that is, those that demand legal regulation, criminal law is the most formalized of all. Of all, as we said, it is only the most serious. It is one that is conceived for the protection of the most important interests against the most serious attacks to ensure, as we said, peaceful human coexistence. We are exploring the terminology formal criminal law versus material criminal law. What are we referring to from a formal point of view? Criminal law is a set of rules of legal principles and assessments that devalue and prohibit the commission of crimes by associating them with a penalty or a security measure. From a material point of view, criminal law is a means of social control, as was stated a moment ago very formally, the purpose of which is to maintain social order. Why? Because the object of protection is that of legal assets, the concept of which we are going to analyze later. What are the criminal legal consequences? Criminal law is defined by the dractiveness of its sanctions through a vicarial system, because penalties and security measures are contained at the same time. What is the penalty? Punishment consists of evil. Why? Because it refers to the deprivation or restriction of legal assets of people. The penalty is based on guilt and is a consequence of a crime. The security measure, on the other hand, is the consequence of a typical and unlawful act. Always to be constitutional, it has to be post-delictual. The security measure is the legal consequence that should be applied to a typical unlawful act, not to a crime. They also consist of deprivation or restriction of legal assets, but the security measure is based on the criminal dangerousness of the subject, not on the guilt of the perpetrator. We will analyze these categories in detail in other capsules later. Objective criminal law and subjective criminal law. Objective criminal law, also called ius penale, is the set of norms of legal norms. Subjective criminal law, on the other hand, consists of the power that the state has to punish. This exercise, that of subjective criminal law, is subject to limits, since it cannot be arbitrary. Criminal law is part of public law. Why? Because the holder of punitive power is the state, and individuals must submit to the so-called principle of subordination. Do we have to say that criminal law is not only regulated in the penal code, it is also regulated in special laws? And there we have the discussion, what is main criminal law and what is criminal law? Accessory global science of criminal law. What it contains the study of sciences linked to criminal phenomena. And it is made up of multiple disciplines. For example, dogmatics that deals with substantive criminal law. Substantive criminal law is through the general part and the special part. The general part contains the study of dogmatic categories that are common to all crimes, and the special part contains the study of dogmatic categories that are specific to certain crimes or certain groups of crimes. Criminal procedural law consists of the study of formal criminal law, also called adjective criminal law, and refers to the procedural rule that allows the application of criminal law. Penitentiary law refers to executive criminal law, that is, the rules on the initiation, compliance and control of precautionary measures depriving of. Freedom from prison sentences and alternative sentences. For its part, juvenile criminal law deals with the criminal norms of young people from 14 to 17 years of age through a special law. Law 2084, the special precepts on criminal law, formal material, punishment measurement, and penitentiary in this regard. I mean young people between 14 and 17 years old. They are also contained in the aforementioned special law. Criminology, for its part, is an interdisciplinary discipline that deals with crime as an empirical phenomenon, studies social control, the victim, the perpetrator, and the punishable act. Finally, criminal policy tries to determine, through political criteria in a broad sense, the behaviors that should be considered crimes and the means to prevent them. That is, it refers to the state's policy towards crime. That is, its tolerance and intolerance towards behaviors that can be estimated as deviant or not. We now move on to another topic, which is that of the theory of criminal legal norms. What is the structure of the penal rules? We know that an assumption of fact and the legal consequence constitute the two cardinal elements in the structure of every legal norm. The factual assumption can be, according to the definition, that Professor Santiago Mirpuch proposes the crime, the dangerous state or an imbalance of a patrimonial nature, and the legal consequence will vary depending on the type of case. In fact, and in this sense, the legal consequences can be punishment, security measures, and civil liability. What is primary standard? And that's a secondary rule. From the point of view of the logical structure of criminal norms, only the distinction between factual assumption, which is its budget, and the legal consequence is valid, and the distinction precept, sanction, refers to its imperative meaning rather than its formal structure. But for it to be valid at that level, the concept must be perfected by differentiating between primary norm and secondary norm. What is the primary rule? It is the one that is addressed to the citizen, that prohibits or orders him to act in a specific way. The secondary rule, on the other hand, is addressed to the judge. And does it force you to apply the legal consequence when the fact or your budget occurs? Here we present a scheme to illustrate the following content of the subject that we are going to see in the next capsule, and that we are going to begin with the explanation of this scheme.